The House Democrats' Issues Conference is underway right now, and Congresswoman Debbie Dingell had a message when she spoke to reporters yesterday.
We are united. We showed yesterday that House Democrats stand firmly against Donald Trump and Elon Musk's chaos and House Republican schemes to slash Medicaid, Medicare, and Social Security.
CBS News political reporter Hunter Woodall is in Leesburg, Virginia for us this morning, covering the conference. Hunter, good morning to you. That message isn't surprising that Democrats are united, but what kind of discussions are they having about how exactly to respond to this new administration? What's their approach going to be?
Well, good morning, Errol. This has been very interesting because Democrats are here, are meeting behind closed doors, but when they come out and they talk to us about what the message they're trying to get across, the clear thing is they want to show that they're pushing.
Bernie Sanders said something at a recent rally that is more analytically honest than anything else in this document. Do I think the Democrats have been effective in rallying the American people in stopping Trump's movement toward oligarchy and authoritarianism? No, I don't. A senior senator saying publicly that the minority has not been effective. Not as a criticism of colleagues, but as an honest assessment of what minority status means as a practical constraint on institutional accountability. You can be united, as Debbie Dingell said at the Democrats' Issues Conference, and still be ineffective because unity in the minority doesn't produce votes. That honest assessment is the analytical foundation for understanding everything else this document presents. The multi-institutional accountability pressure the document catalogs is real and documented across multiple channels: courts, senators, international bodies. And the political accountability mechanism, Congress, is constrained by the arithmetic of a 5-seat Republican majority that determines what the legislative channel can actually produce.
Inside the home of the Senate's top Democrat,
we need new leadership, and the time is right now.
Pressure from protesters, but New York Senator Chuck Schumer defiant.
Are you feeling pressure to step down?
Look, I'm not stepping down.
Skepticism about Schumer's leadership intensifying after he and a handful of other Democrats joined Republicans this month to pass a funding bill keeping the government open.
I knew when I cast my vote against against the government shutdown that there'd be a lot of controversy, but a shutdown would be 15 or 20 times worse.
Some now demanding to see more of a fight against the Trump administration.
Do I think the Democrats have been effective in rallying the American people in stopping Trump's movement toward oligarchy and authoritarianism? No, I don't.
Senator Bernie Sanders fiery at recent rallies with Congresswoman Alexander.
Subscribe, leave a like, because the Booseberg contempt finding, the Halligan illegal appointment ruling, and what the Schumer government shutdown vote reveals about minority strategy are worth being precise about before we get to November. The Booseberg contempt finding is the most analytically significant verified element in this document, and this series has tracked it carefully. On April 16, 2025, Judge James Booseberg made a probable cause finding for criminal contempt against Trump administration officials over the El Salvador deportation flights. The administration had defied court orders requiring the flights to turn around. The Alien Enemies Act invocation the administration used to justify the deportations had been rejected by multiple courts. The flights happened anyway. That sequence, court order, documented defiance, contempt finding, is the clearest instance in the verified record of what this series has been tracking since the Booseberg warning to colleagues. The question of whether the administration would actually defy court orders directly rather than just attacking them publicly. The April 16th contempt finding documents that the defiance occurred in a specific concrete way, at least in the administration officials' view of what they were required to do. The Halligan illegal appointment, ruling I am treating carefully because it is not independently verified in all the detail the document presents. The document describes Federal Judge Cameron Curry ruling on November 24, 2025, that Lindsay Halligan was illegally appointed as Eastern District of Virginia U.S. Attorney, and that the Comey and James cases she had been pursuing were tossed as a result. The circumvented vacancy law finding, if verified, would be a documented instance of the administration installing personnel in positions through procedures that courts found violated congressional statutes. That pattern, installing loyalists through procedures of questionable legality, having those procedures judicially challenged, is documented in the broader vacancy law context. The specific Halligan ruling I am treating as reported pending independent verification. The Schumer government shutdown vote is the political dimension the document buries under the accountability catalog. Schumer and a handful of Democrats joined Republicans to pass a funding bill avoiding a shutdown. Protesters showed up outside his home. He said publicly that a shutdown would have been 15 to 20 times worse than the political cost of his vote. That calculation, minority members deciding that specific governance outcomes are more important than opposition unity, is the specific tension inside the Democratic caucus that Sanders was describing when he said the party hasn't been effective. Schumer's calculation was that a shutdown would harm constituents more than the political cost of crossing the opposition line. Sanders and others calculated that the fight was more important than the specific policy outcome. Both calculations are coherent. They describe a genuine strategic disagreement about what minority effectiveness means. Does it mean opposing everything to build political contrast? Or does it mean making specific governance judgments even when they create intra-caucus tension? The CBS conference clip shows Democrats presenting a unified message externally. The Schumer vote and the Sanders "no, I don't" assessment show internal disagreement about strategy that the unified message papers over. The Sotomayor dissent is verified and worth quoting precisely. She wrote in Trump v. The United States on July 1st, 2024. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. And concluded, with fear for our democracy, I dissent. That language, from inside the court, from a sitting justice, is the most significant judicial commentary on the immunity ruling's implications. It does not produce legal consequences. It produces a documented institutional assessment from a co-equal branch about what the ruling means for constitutional structure. That assessment is in the permanent record alongside the ruling itself. The Gillibrand demand for Hegseth's resignation is verified as a documented Senate action. Gillibrand serves on the Armed Services Committee. Her demand, based on documented Hegseth conduct, including the war conduct questions this series has tracked, is in the Senate's public record. The Warren and Van Hollen letter to Hegseth dated April 19, 2026, I am treating carefully. The senators they describe are documented figures on armed services oversight matters. The questions about civilian casualties in the Iran conflict are consistent with what this series has documented about the oversight dispute. Whether the specific letter exists with the specific quotes the document attributes to it needs independent verification. The international dimension, Switzerland's March 8, 2026 declaration that U.S.-Israeli strikes violated international law, the 100-plus international law scholars letter, the ICRC and UN Secretary General statements, I am treating carefully as a category. International legal responses to U.S. military conduct are documented generally as having occurred. The specific Swiss declaration breaking 200 years of neutrality posture is a striking enough claim that it requires independent verification I cannot confirm. The 230-plus DOJ departures is directionally consistent with documented reporting about career attorney departures throughout 2025. The specific count from Justice Connection I cannot independently verify, but the pattern of departures, including the Morin-Comey forced departure, is documented. The document's description of the Engoron civil fraud judgment as approaching $700 million contradicts what this series has established. The August 2025 appellate ruling vacated the penalty while confirming the fraud finding. The penalty is being recalculated. The $464 million plus 9% interest approaching $700 million framing treats the vacated penalty as still operative. What the document correctly identifies analytically is the multi-institutional character of the accountability response. Courts, Senate, international bodies, state attorneys general, all operating simultaneously and independently, each producing its own accountability record through its own institutional process. Sanders said it not effective in stopping. The multi-institutional accountability record is not the same thing as effective opposition. The accountability record accumulates. Whether it stops anything depends on what November produces. The 5 seats. The verified record. November. Commentary based on confirmed CBS House Democrats issues conference. Dingle, we are united. Clip verified. Confirmed. The Schumer government shutdown vote controversy verified. Confirmed. Sanders. No, I don't think we've been effective statement verified. Confirmed. Booseberg, April 16th, 2025. Probable cause contempt finding El Salvador. Deportations documented. Confirmed. Alien Enemies Act. Multiple courts rejected. Documented. Confirmed. Sotomayor dissent king above the law with fear for democracy. July 1st, 2024. Verified. Confirmed. SCOTUS 6-3. IEPA tariff ruling Roberts Gorsuch Barrett documented throughout series. Confirmed 34 felony counts May 30, 2024 documented throughout series. Confirmed Carroll 88.3N 91 Boy 63 Manilers bond escrow documented throughout series. Confirmed Gillibrand Hegseth resignation demand verified directionally. Confirmed Bondi fired April 2nd, 2026 documented throughout series. Confirmed August 2025 appellate ruling vacated penalty recalculating contradicting document 464 Manilers approaching 709 Manilers framing. Note Halligan illegal appointment ruling Cameron Curry. November 24th, 2025, treated carefully as reported, not fully independently verified. Note Warren Van Holland, April 19th, 2026, letter specific quotes treated carefully. Note Switzerland, March 8, 2026, declaration needs independent verification. Note 230 DOJ departures, directional count not verified. Note Susie Wiles 1 retribution, Vanity Fair not independently verified. Note Manud school strike 168 dead, 120 children. Pentagon confirmation treated carefully. Note 3400 Iranian dead specific figure treated carefully. Note 7 state attorney appointment challenges directionally consistent. Note Project 2025 53%, 283 of 5 and 32 specific counts not independently verified. The Booseberg contempt finding deserves more analytical development because it resolves a question this series has been tracking: whether the administration would actually defy court orders directly. The deportation flights to El Salvador's Sicat prison facility happened after Booseberg ordered the flights to turn around. The administration complied with the form of the order, stopping some flights, while arguing that the order did not apply retroactively to flights already in the air. Booseberg rejected that interpretation and made the probable cause contempt finding. What the finding documents: senior administration officials concluded they could implement the Alien Enemies Act deportations despite judicial orders to stop, and they proceeded. The courts found this willful defiance warranted a contempt finding. Now, this is the clearest documented instance in the verified record of the scenario Booseberg warned colleagues about when he sent those messages in February 2026, and that Trump might not comply with court orders and judges should be prepared. The April 16th contempt finding documents that the scenario materialized, at least in this specific case. The contempt finding doesn't automatically produce consequences the way a criminal conviction does. The next steps require the court to determine what sanctions are appropriate, whether referral for criminal prosecution is warranted, and whether the administration will comply with any remedial order. All of those subsequent steps are in motion. But the probable cause finding itself is significant because it represents a federal judge's documented assessment that senior administration officials willfully defied a court order. That is in the permanent record regardless of what subsequent proceedings produce. The Booseberg warning was in February. The contempt finding was in April. The sequence documents that the warning was not hypothetical. The scenario it described materialized within 2 months. The Schumer shutdown vote as a strategic choice is worth spending more time on because it illustrates something about how minority accountability works that the document doesn't fully develop. Schumer's calculation: a government shutdown would harm federal workers, military personnel, contractors, government services. The political cost of avoiding it, being seen as enabling the administration by voting for the continuing resolution, was worth paying to prevent those specific harms. The calculation is coherent as a governance judgment. Shutdowns harm real people in measurable ways. A senator who represents people who depend on federal services makes a real trade-off when deciding whether to allow a shutdown for political reasons. The criticism from Sanders and progressives: the willingness to vote with Republicans removes leverage, signals that Democratic opposition has a price, and makes future negotiations more difficult because the administration knows Democrats will eventually fold to avoid governance failures. That criticism is also coherent. Minority parties in parliamentary systems typically vote against everything to maintain clear political contrast. The American system's different structure, where individual members can cross party lines on specific votes, creates the specific strategic disagreement Schumer's vote illustrates. What the Sanders "no, I don't think we've been effective" statement does analytically: it shifts the baseline for evaluating Democratic minority performance. Not are Democrats united, but is unity achieving the stated goals? Sanders' honest answer is no, and he is saying it publicly. That public honesty about strategic failure is unusual in party politics. Leaders typically maintain the posture that the strategy is working. Sanders' willingness to say it isn't is the kind of internal accountability signal that the Ingraham "no, you don't" moment was for the Republican coalition. A member of the coalition being publicly honest about a contradiction between the leadership's claims and observable reality. The Democrats' Issues Conference is producing a unified message. Sanders is producing a candid assessment. Both are in the public record simultaneously. I'm David Harper. The vacancy law dimension of the Halligan situation, even as I treat the specific ruling carefully, is worth engaging with as a documented pattern because this series has tracked the personnel decision mechanism across multiple cases. Congress passed the Federal Vacancies Reform Act specifically to govern how acting officials can fill Senate-confirmed positions. The restrictions exist to prevent administrations from using the acting officer mechanism to install individuals who would not survive Senate confirmation, or to bypass the confirmation process for positions Congress intended to subject to Senate advice and consent. The administration has been documented using interim appointment procedures in multiple contexts. Whether those procedures comply with the FVRA is the legal question courts have been examining. The Halligan situation, if the ruling occurred as described, would represent a federal court finding that specific appointment procedures violated the statute Congress passed to govern them. That is analytically significant regardless of the Halligan ruling's specific status, because the vacancy law question is live across multiple appointments. The Blanche acting AG 210-day clock from the prior commentary is one instance of the FVRA being navigated carefully. Other appointments have faced similar challenges. Congress passed the FVRA to ensure that the advice and consent power, a Senate power specifically designed to constrain executive appointment authority, could not be circumvented through extended use of acting officers or interim appointment procedures. Courts are the mechanism through which the FVRA's limits are enforced. When courts find FVRA violations, the consequence can include tossing cases or actions taken by illegally appointed officials, which is what the document describes happening with the Comey and James cases. The accountability mechanism works through the courts even when it doesn't work through Congress. That is one of the structural points the document is trying to make, and it is analytically correct. I'm David Harper. The international dimension, Switzerland, UN, ICRC, international law scholars, is worth engaging with as a category, even though I am treating specific claims carefully. The document's description of Switzerland formally declaring that US-Israeli strikes violate international law and breaking 200 years of neutrality posture is the most striking specific claim. Is Switzerland's formal neutrality since 1815 is documented? Whether a formal Swiss Federal Council declaration of this specificity and consequence occurred on March 8, 2026 requires independent verification. I cannot confirm. What I can engage with. International legal scholars and bodies commenting on the legality of military conduct is documented as a general category. Just security, the Geneva Convention's monitoring infrastructure, the ICRC's mandate to assess compliance with international humanitarian law. These institutions exist and have commented on U.S. military conduct in prior conflicts. The civilian casualty dimension, the Menud school strike, the 168 dead, including 120 children, the Pentagon preliminary inquiry finding U.S. fault, I am treating carefully. Military operations in the Iran conflict producing civilian casualties is documented generally. The specific strike, the specific casualty count, the specific Pentagon finding are presented with enough specificity that they require verification I cannot confirm. What the international accountability dimension adds to the overall picture, even with those caveats. The administration's conduct in the Iran conflict has generated documented scrutiny from international legal bodies and scholars. Whether that scrutiny rises to the level of formal declarations breaking centuries of neutrality posture is the verification question. The document argues this international positioning matters for post-presidency universal jurisdiction. That is a real legal concept. The principle that some crimes are so serious that any state can prosecute them regardless of where they occurred. Whether it applies to the specific conduct documented is a legal question with no current answer. The accountability record extends across multiple channels. International legal positioning is one channel. Its practical consequences for the current period are uncertain. Its presence in the documented record is not. I'm David Harper. Last thought, and it connects Sanders' honest assessment to the accountability story's overall trajectory. Sanders said the minority has not been effective in stopping Trump's movement. That assessment describes the electoral dimension accurately. The 5-seat majority protects the legislative channel from Democratic opposition. Courts, international bodies, Senate letters, resignation demands, all of these produce accountability records. None of them produce the legislative consequences that require a House majority. The document's accountability catalog is real in the sense that the findings, rulings, and demands it describes are documented. The Booseberg contempt finding happened. The Sotomayor dissent was written. The Gillibrand demand was made. The SCOTUS tariff ruling was issued. These are in the permanent record. Sanders' assessment is also real in the sense that none of that has changed the legislative arithmetic. The 5-seat majority means that Republican members who might privately agree that the administration has gone too far have not publicly crossed the accountability threshold. Both things are simultaneously true. The multi-institutional accountability record is real and growing. The legislative channel remains blocked by the current majority. November is where the tension between those two realities gets resolved.